appellate process is completed?
I anticipate that because the process of organizing that could be lengthy, we would begin that process. However, we likely wouldn't file that until a favorable appellate court ruling is correct.
This judge didn't get to the constitutionality argument, but is there a case either filed by you or somebody else in the pipeline that could still force that issue?
Well, you're talking about the property rights argument. If this case were remanded, that issue would be reopened. Currently, there's no case pending. We have the only case of that nature pending, and we were awaiting the outcome of this case. We are pleased with the ruling because it allows our client, Zeno's, to stay open for business rather than being seized by the state. We are pleased because it at least draws the state agency's authority back to its constitutional boundaries. So while we didn't win on all fronts, we have to be satisfied with the results we obtained for our clients and for business owners across the city. That's an interesting question.
Let's just say this. Any bar that has closed down, it's attributable to that. I can tell you that. You do your own investigation. I invite you to do your own investigation. Talk to any permit holder about the losses they've sustained due to this policy, this law, and it goes from 10 to 30% and higher. Any of those numbers are killers to our industry.
We had an expert economist testify at the Zeno's trial that isolating all of the variables, including the downturn in the economy, the smoking ban itself has resulted in about 900 job losses in the bar industry in Franklin County alone.
I'm just trying to get my hands around this, but is the flaw here ultimately in the law itself or in the Department of Health's rules that it promulgated under the law for enforcement? I'm trying to get an idea. Can the Department of Health fix this just by going back before JCAR with a new set of rules?
They didn't promulgate rules on this matter. Instead, they chose to enforce it without promulgating the rules. That in itself is one of the problems, and one of the things that we argued is that if you're going to make up these set of rules and then use them ad hoc, you've got to commit that to notice and comment agency rulemaking as required by law. The health department didn't do that. The court went beyond that claim of ours and said, look, they've got a policy, they've crafted it, they have not committed it to writing, and it flagrantly exceeds what is permitted by the law. So if they were to craft rules that just embody in writing what they've been doing, those would also be unlawful. Could they do something else? Maybe.
Craig, what's the universe of permit holders that would be affected by this statewide? How many?
Oh, I would say it's always a tough question because there's great frictional change in the number of people, but I would say 12,000 permit holders, somewhere in that range.
That means 12,000 businesses?
12,000 businesses, yeah. That would be my estimation.
Is your bars and restaurants both?
Yeah, bars. I would say bars and restaurants that lean toward more alcohol than food, or where it's 50-50 roughly.
You're not talking the Applebee's or the Fridays or anything like that?
Yeah, they're affected by it too, but it wouldn't be as stark as really a bar that spends most of their time entertaining guests with alcohol.
If you look at who's been cited under the law, and that data is out there available, we used it at the Zeno's trial, it's almost always this small corner bar that caters to a working class crowd, union crowd that comes in after work and wants to smoke a cigarette and have a beer on their way home from work. Or on the other end, the crowded local bar where somebody's smoking in the back corner and the bartender perhaps can't see that person smoking. You very rarely see citations of restaurants or of any place like an Applebee's or any kind of chain bar or restaurant. Very, very rare.
And looking at the court documents, it looked like Zeno's, whenever it was issued a fine, did not appeal, didn't go through the administrative process. Was there ever a point at which he actually went through the process under the law to challenge this?
Administrative hearing officers cannot make constitutional rulings. So Zeno's has constantly believed since the beginning that this method of enforcement was unconstitutional, if not the law itself. And in Ohio, an administrative agency cannot render a constitutional holding. So going through the administrative appeals process would have been futile. In fact, the Attorney General, by filing this action and attempting to make an example of Zeno, has actually opened the door for us to get into court and make this challenge the way that we've wanted to for some time.
Was that the idea? Was that what you were waiting for?
We were highly appreciative of the Attorney General granting us that opportunity.